Hello everyone, my name is Aryan Sinha and I'll be talking about the insolvency resolution process for corporate persons under Section 7. We all know that Section 7 deals with the initiation of CIRP of a financial creditor. The whole process of CIRP is covered under Section 6 to 32A of Insolvency and Bankruptcy Code. Now I will talking about the pre-initiation of CIRP, that is before filing of Section 7 application. We all know that the prior stages of Section 7 is not been reinstated in the IBC code. Now, I'll be talking about the certain compliances which need to be followed for filing an application under Section 7. Firstly, the loan account of the corporate debtor must be declared as NPA. Now, after that, when the loan account of the corporate debtor is declared NPA, a legal demand notice under Section 13 Clause 2 of SURFACI Act is issued by the financial creditor. After that, a final loan recall letter is in issued in the favor of corporate debtor so that the corporate debtor can be given a final opportunity to clear its all due and so that the default amount can be vanished. After that, when the corporate debtor fails to adhere the legal demand notice under Section 13 Clause 2 and the compliances of loan recall letter, so and the after that, a CA is appointed which issues a certified financial statement of the corporate debtor. Now, the default amount which is stated in the certified financial statement is been uploaded to the National E-Governance Services Limited, that's NECL, for the authentication of the default amount. In this step, when the default amount is uploaded to the NECL, the corporate debtor must reply within 30 days for any objections if is raised by the corporate debtor. If not, the NECL authenticates the default amount, and after that, the same defaulted amount and the report of NECL is duly sent to IBBI, that is Insolvency and Bankruptcy Board of India, for its acknowledgement. After that, when the IBBI acknowledges the default amount, then the financial creditor is eligible to file an application under Section 7. Now, for filing of Section 7, the following compliances have been compiled, that is the NPA, legal demand notice under Section 13 Clause 2, loan recall letter, CA certified financial statement, authentication report from NECL, IBBI acknowledgement. Along with the application under Section 7, banking license of the financial creditor must be annexed. Secondly, the authorization letter of the financial creditor must be annexed. Loan security kit of the corporate data must be annexed. The company master data must be retrieved from the Ministry of Corporate Affairs of the corporate debtor. Now, for whole CIRP process, an IRP is required, and in that process, the financial creditor can approach NCLT and recommend his own personal choice of IRP. For that, a consent form needs to be filled on behalf of IRP under the heading of Form AA, which can be downloaded from the IBBI website. Now, the application under Section 7 must be duly formatted under the format of Form 1 along with the Form C, which reinstates about the financial claim by the financial creditor. After compiling all these necessary compliances, service of petition will be filed before the Honorable NCLT with a court fees of 25,000 rupees. Now, I'll be talking about the post initiation of CIRP. Stage 1 consists of initiation of CIRP. The CIRP of a corporate debtor commences with an order from the adjudicating authority admitting an application to initiate the CIRP of the city filed by a financial creditor under Section 7. The date of this order becomes insolvency commencement date, that is issued after the accepting of application under Section 7. Now, the second stage comes about the moratorium and public announcement. Declaration of moratorium is dealt under Section 14 and public announcement is dealt under Section 50. Now, in the moratorium, three essential things are mentioned. Firstly, appointment of an insolvency resolution professional under Section 16, and and a notification which states that no new pending suits or stay on no new suits and stay on pending suits must be adhered. Now, after the commencement of CIRP, the control and custody slash management of affairs of the corporate debtor is transferred to the hands of the IRP, so appointed, and the powers of the board of directors or the partner of the corporate debt shall be suspended, and all those powers must be given to the IRP. This whole section is covered under section 17 and 18 of the IBC code. Now, as I stated about the public announcement in section 15, for that, an IRP needs to issue a public announcement under Form A of the Form A of the corporate insolvency resolution process for corporate persons to invite claims from creditors of the corporate debtor. Now the third stage talks about the constitution of committee. Firstly, firstly under section 21, collation of claims, verification of claims, and constitution of committee of creditors are dealt under section 21. Along with this, a Form B, which can be downloaded from the IBBI website, must be issued along with the public notice within 14 days of the commencement of insolvency resolution process. After this, filing of report certifying institution of the COC and list of creditors to the adjudicating authority. After this, the IRB needs to hold the first meeting of COC within 7 days of filing the report certifying the constitution of the committee of creditors. The committee shall fix the expenses to be incurred on or by the RB, and the expenses shall constitute insolvency resolution process cost. The committee of creditors is the decision-making body of the corporate debtor for the very reason that is the investment and interest of these creditors which is at stake. Action by the IRP/RB are to be ratified by the member of the COC. Now, the stage 4 talks about the appointment of resolution professional. This stage will talking about the power and control and duties of the insolvency resolution professional, which will be directly transferred as a resolution professional. The IRP, which this section states that the IRP so appointed may or may not be appointed as a resolution process professional under section 22, which is also same is decided upon the meeting of the COC for which 66% votes of COC is required. After the appointment of resolution professional, the RP must file an application for avoidance of preferential transaction under section 43, application for undervalued transaction under section 66, and defrauding transactions under section 26. So that the smooth process of CARP must be commenced in the favor of corporate debtor. Now, the fifth stage talks about the role of resolution professional. In this, when the COC is not satisfied with the duties and roles of the resolution professional, the COC must file an application before the Honorable NCLT for the replacement of RP, which must again be constituted after the 66% votes of the COC. Now, under section 28, it talks about the approval of COC for certain matters or resolution professional. In this section, there are certain measures which must be taken by the RP after the consent and approval of COC. For example, creation of any security interest of an asset, or if the RP wants to change the capital structure of the financial structure of the corporate debtor. After that, under section 29, preparation of information memorandum must be initiated. The contents of information memorandum consist of assets and liabilities of the corporate debtor, financial statements of the corporate debtor, which includes provisional transaction audit report and the audited transaction report, the consolidation of claims, and the debt of related parties. Now we'll be talking about the stage 6, which talks about the initiation of expression of interest process for submission of resolution plan. Resolution plan. The RP shall publish brief particulars of the invitation for expression of interest in Form G. This section will be talking about the appointment of a resolution applicant. The eligibility of a resolution applicant must be decided by the resolution professional. The following candidatures must be eligible for the appointment of the person as a resolution applicant. It can be a chartered accountant, company secretarial, cost management accountant, or any other persons who have relevant and adequate experience in the field of insolvency and bankruptcy. The prospective resolution applicant shall must submit the resolution plan within the due date prescribed in Form G. This will be talking about that the resolution applicant must submit a resolution plan in favor of the corporate debtor, and the plan must be in the accordance with the waterfall management which has been stated in the chapter of liquidation under the Insolvency and Bankruptcy Code. Now, RBI will check whether the plan submitted by the resolution applicant meets the basic criteria of the requirement of the code or not. After that, the RBI shall submit to the committee of all the resolution plans which comply with the requirements of the code and regulations made thereunder. After that, when the COC is satisfied with the resolution plan, then the COC must approve the resolution plan. Now, we'll be talking about the stage 7 that talks about the approval of resolution plan, where the resolution plan is approved by the member of the COC with 66% of votes. The RP shall file an application before the adjudicating authority for approval of the plan. Following this, adjudicating authority may, upon discretion, accept or reject the same. The resolution plan is implemented and becomes legally operative on the corporate debtor and all parties if the NCLT authorizes it. The tribunal may order the corporate debtor's liquidation if the NCLT does not approve the resolution plan or it does not receive the resolution plan before the expiry of CIRP days. In this, the CRP days on the timeline of this is of about 180 days, which can be extended by the 90 days. Within the period 270 days, if the resolution professional does not able to provide an adequate resolution plan before the NCLT, then the NCLT will direct the proceedings of liquidation under the Insolvency and Bankruptcy Code of the corporate debtor. So, guys, I have basically listed out a brief guideline of the practical approach of CIRB under Section 7. If there are any questions, please let me know in the comment section. Thank you.